Hello, everyone. Good afternoon. My name is Doha Meki, and I'm the Principal Deputy Assistant Attorney General for the Antitrust Division. It is my privilege to open the presentation of the Sherman Award. On behalf of the Antitrust Division and the department more broadly, I want to extend a warm welcome to the hundreds of guests with us in person today and the many more who join us virtually. I want to welcome our honoree, Bill Baer, who is joined by his wonderful family. They include his wife, Nancy, his sons, Michael and Andrew, and his beautiful granddaughters, the youngest of which is 5 weeks old, and who we expect to join us in the honors classes of 2046 and 2049, respectively. We also welcome the many distinguished guests who join us here today, including Senator Amy Klobuchar, former Attorney General Loretta Lynch, former Associate Attorney General Tony West, Director of the Consumer Financial Protection Bureau, Director Rohit Chopra, and all of the commissioners of the United States Federal Trade Commission, and I'm fairly certain it violates one of their commission rules that they are all here together somehow. Thank you to all of you for joining us for this special event. The John Sherman Award is the Justice Department's highest antitrust honor. Created in 1994, the Sherman Award is presented to a person for outstanding contributions to the field of antitrust law, the protection of free and fair competition, and the preservation of our economic liberty. Prior honorees include former Chairman Robert Pitofsky, Judge Richard Posner, former AAG Jim Rill, and Professors Phil Arita and Milton Handler, among others. One of our illustrious recipients sits with us this afternoon, the Honorable Diane Wood, Senior Judge of the U.S. Court of Appeals for the Seventh Circuit. She is a former DAG in the Antitrust Division, and she is a visionary leader of the type the Sherman Award was created to celebrate. We are so proud to add to those ranks today. The award itself is named for Senator John Sherman of Ohio, for whom our first antitrust law, the Sherman Act of 1890, is named. By the late 19th century, members of both parties were concerned with the rise of the trusts. Monopolies had pierced the national consciousness, and Senator Sherman later became a passionate advocate for competition and against monopolies. Senator Sherman argued that his law against trust was necessary to preserve, and I quote, our industrial liberty, which lies at the foundation of the equality of all rights and privileges, end quote. His law passed overwhelmingly in the Senate by a vote of 52-1, and it passed unanimously in the House without dissent. The Antitrust Division does not present the Sherman Award regularly. We reserve this honor for those once-in-a-generation talents whose legacy undeniably deserves praise from the entire antitrust community. And today we add to that small list. Our honoree, Bill Baer, is the only individual to have led antitrust enforcement at both of our U.S. antitrust agencies. First as director of the Bureau of Competition at the FTC during the Clinton administration, and later as AAG for the Antitrust Division during the administration of Barack Obama. Bill, of course, is more than an impressive resume. He has a living legacy, much of it seated among us today. And there are many things I could tell you about the wonderful person and enforcer Bill Baer is. But I have been encouraged to be brief. After all, there are many distinguished guests who have traveled long distances to tell you about Bill. But as a point of privilege, I will share just one story. I first encountered Bill Baer at the New York State Bar Association annual meeting in 2014. I was a second or third year associate working in New York, and Bill was invited to give the keynote address for the evening gala. In a word, I was dazzled. Not just because Bill was and is a larger-than-life figure, or because of Bill's tremendous power of persuasion, but because I thought he expressed a vision for an antitrust division that could make a real difference for people in our market economy. I thought that if I worked hard enough, that maybe I could be the kind of person who also could be worthy of this great institution. This great institution that Robert Jackson, Thurman Arnold, and Bill Baer have built. A few months later, Bill's deputy, Leslie Overton, gave a speech announcing that the Antitrust Division would resume hiring after many years of post-financial crisis sequestration. And so I applied that summer, received an offer, and the rest, as they say, is history. Bill has inspired so many of us personally. He has pushed us to become more able enforcers. He has given us an exemplary model of a whole-of-life devotion to antitrust and competition values. And after learning from him, many of us developed an approach to antitrust enforcement which lives out that sacrosanct imperative set down by Senator Sherman 134 years ago, that if we will not endure a king as a political power, we should not endure a king over the production, transportation, and sale of any of the necessities of life. And that if we should not submit to an emperor, we should not submit to an autocrat of trade. When we announced our intention to honor Bill, countless friends and colleagues reached out on their own, offering their concurrence that Bill was so clearly deserving of this award. This was particularly true for those who had the privilege of working with Bill when he served as our AAG. One of those staff members has returned to the Great Hall today to reprise the role that she often performed when Bill himself led antitrust division ceremonies. I ask that you now please rise as Shawnee Bell, who has since retired from the Antitrust Division, once again sings the national anthem in this historic setting.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rocket's red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say, does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
Hello, everybody. I'm Jonathan Cantor, and I am former staff attorney of the great Bill Baer. I'm absolutely thrilled to be here with so many wonderful, distinguished guests and friends to honor our Bill Baer. I would also like to acknowledge an incredibly special guest today, someone who's not just a champion for antitrust, but someone who actually wrote the book called Antitrust. Senator Klobuchar, it's great to have you here. Thank you for all that you do. So I have the privilege to introduce a number of wonderful speakers today who are here to honor the great Bill Baer. It's customary at a Sherman Award ceremony, which does not happen very often, to include remarks from individuals both inside and outside the division to highlight the extraordinary achievements of the recipient. And our honoree today certainly has no shortage of individuals who hold him in such high regard. And so today we are thrilled to invite just a small few to represent the so many who care so deeply and admire so much Bill Baer. Bill's time as Assistant Attorney General of the Antitrust Division was marked by strategic thinking, vigorous enforcement of the antitrust laws, and a truly all-star leadership team. And so our first speaker today, Professor Nancy Rose, is one of those all-stars. Nancy is a professor of applied economics at MIT. She is a gifted economist who served as Deputy Assistant Attorney General for Economic Analysis from 2014 to 2016 when Bill was AAG. Nancy's unparalleled intellect and creativity were absolutely essential to so many of the victories and achievements that the division experienced during Bill's extraordinary run. We are thrilled to have Nancy here to say a few words, and I am honored to invite to the podium Dr. Nancy Rose.
It's a little hard to follow that introduction, so let's just say, let's lower expectations a bit, and my remarks are not even close to doing justice to Bill, but I'm going to try. So it's an immense pleasure and a privilege to stand before you today to celebrate Bill's extraordinary contributions to antitrust, to celebrate the indelible mark that his commitment to public service has left on both the Federal Trade Commission and the Antitrust Division. While I don't think my remarks are going to do justice, I think, Bill, I hope you just look out at the crowd of people who have assembled to be part of this ceremony and recognize that you all and your presence here say more than I possibly could. So the John Sherman Award, if you've just heard, for lifetime contributions to antitrust is perhaps the highest recognition one can receive in our field, though I'll acknowledge that Bill has received others that might be in their agencies comparable, including the Miles Kirkpatrick Award from the FTC and the AAI's Alfred E. Kahn Award for Antitrust Achievement. But I'm confident that the Sherman Award will hold a particularly special place in Bill's heart. And that's because while you may be able to take Bill Baer out of the DOJ, I don't think you can take the DOJ out of Bill Baer. He led enforcement policy while inside Main Justice, and he has been one of your greatest advocates since leaving. This award is not just about the cases he's won or the policies he's shaped. It's about a career grounded in integrity, leadership, and an unwavering dedication to protecting competition and the welfare of the American public. I can't possibly do justice to all of that in the probably 8.5 minutes I have left remaining. So I'm going to use the rest of my time to focus on his what it was like to work for Bill from inside the division. So I think you'll hear more about his record of service and accomplishments from others. I'm going to not dwell on those. I'm not going to dwell on his deep expertise in antitrust law and uncanny savviness for case strategy that Jonathan's alluded to, nor will I discuss his effort to recruit more Green Bay Packers fans from the antitrust ranks, despite appearing at certain division events in full uniform. When Aviv Neveau called me in 2014 to see if I might be interested in joining the division as the economics deputy after he was returning to academia, I hesitated. I wasn't sure I could extricate myself so quickly from my various academic and professional commitments. And Aviv listened to this for a while, and then he said, "Nancy, you likely will have other opportunities to consider working at the DOJ, but those will not be with Bill Baer." It took less than a morning meeting with Bill's front office team and Bill himself a week later to appreciate what Aviv meant by that statement. And soon after, I embarked on the most awesome 28 months of my career. But my experiences are not unique. My remarks shamelessly crib from many others who have also worked for Bill and who have generously shared their thoughts with me in the weeks leading up to today. When I asked people for the key words they associate with Bill, the convergence was remarkable, and I want to share a few of those with you now. First, leadership. Bill's deep expertise in antitrust law and strategic shrewdness are notable in themselves. But it's been said that Magic Johnson is one of the greatest basketball players of all time, not only because of his own talent and skill, but because he made everyone he played with a better player as well. With apologies to the younger folks in the audience, Bill Baer is the Magic Johnson of antitrust. That's because Bill prioritizes the people he works with. He understood that the success of the division lies not in the speeches that are made or in only the cases that are brought or won, but in the people who investigate, develop, and litigate those cases. And as AAG, Bill invested in those people. He led by fostering a culture of respect, collaboration, and intellectual honesty. He took the time to listen to career staff, to hear their thoughts and concerns, and to build relationships across the division. He made it clear that every voice mattered, and that the success of the division was the collective result of hard work of the entire team, even down to the junior economist sitting in the back row in one of our front office meetings. He was a mentor to many, an inspiration to all, and an advocate for his colleagues every step of the way. Bill was not inclined to have him or his deputies give speeches about what the division was going to do. Bill's motto was, show, then tell. And we showed a lot during Bill's tenure. He invested heavily in increasing the litigation capacity of the division and its phenomenal career staff, and then tested that capacity by going to court. He embraced the benefits of economists working closely with legal teams to advance the enforcement mission through developing new theories of harm, distinguishing problematic from competitive conduct, and strengthening both affirmative cases and compelling rebuttals. I think we continue to see the benefits of many of these investments nearly a decade following his tenure. Second, decisiveness. Bill does not shy from making tough decisions, and he takes responsibilities for them once made. Whether deciding to challenge a merger, take a settlement, or push forward with criminal litigation, Bill ensured that he had a careful analysis, a thorough understanding of the facts, a clear sense of the strategy of the case. He also insisted on hearing dissenting views from a case team or perspectives different from his own. He built on his deep understanding of antitrust law and even deeper insights into enforcement strategy, as well as a principled sense of fairness and commitment to the law enforcement mission of the division. And then he acted. Now, sometimes decisions inevitably make some people unhappy. So Bill took care to explain the reasoning behind his decision to ensure that his team understood not just the what, but the why behind the choice, and he owned those decisions. I remember a criminal matter that Bill decided I should get involved in to help the attorneys think through and better articulate how this behavior might have affected markets. There was, perhaps not surprisingly, a little pushback. Having an economist join your collusion case is the kiss of death, I was told. But Bill stood firm, and within a short period of time, virtually everyone on the case team saw the benefits of joining forces, a benefit that Bill had seen so clearly, even when the rest of us perhaps had not. Third, passion. Bill's passion for the division's work was infectious. His energy, enthusiasm, and commitment to excellence were evident in every interaction, whether he was working with senior leadership, quizzing staff on their investigations, or running party meetings. How many of you remember Bill's animated exchanges in those meetings, which often led the Fitbit on his wrist to register 10,000 steps before the third meeting of the day? His engagement was also personal, such as bringing pizza for an entire litigation team during one of the government shutdowns. And while the business of the Antitrust Division is serious, Bill engaged with a wry sense of humor, administered with a twinkling smile. Communication. Bill understands that antitrust enforcement isn't just about legal theories, abstract principles, or even great economics. It's about real-world consequences. And he understands that being effective requires communicating those consequences both to the public and to federal district court judges in accessible language and memorable graphics. Graphics were one of the highlights of Bill's attention in complaints and litigation material. Some on the Halliburton-Baker-Hughes team might have privately groaned about Bill's 11th hour insistence that the complaint create images for each of the 23 obscure markets in oil field services that we were alleging harm from the merger. But the result was impactful. People loved the pictures. They made real and tangible what was at stake in that case, and the abandonment of the merger a month after the complaint was filed was an enormous victory for competition. Sometimes Bill's instinct for pithy characterization of a case took on a life of its own. In 2016, Bill described the merger to monopoly of two of the largest cinema advertising networks as the type of anti-competitive transaction that should never have made it out of the boardroom. Talk about clear messaging. Bill, while royalties from trademarking that phrase might have created a tidy retirement income flow, I know your greater regret is that we still see too many proposed deals that meet that criteria. In sum, Bill's leadership style instilled a sense of respect and trust that reverberated throughout the division and was reflected in the climb of staff morale during Bill's term and in the deep and long-standing affection that so many of us hold for Bill. His legacy also includes contributions to the broader antitrust community. He's mentored countless numbers of attorneys, economists, and public servants who carry forward the principles he helped to define, and I am beyond proud to count myself among those. Bill's career is a brilliant example of how one individual, through hard work, integrity, and an unyielding dedication to justice, can make an enormous difference in the world. Bill, we're here to celebrate your exceptional career, your visionary leadership, and your unwavering dedication to competition policy. But more than that, and I know I speak not only for those of you in the room, but for many more who were unable to join us today, we are here to say thank you. Thank you for your advancement of the antitrust enforcement agenda, for your friendship, and for making us better people and more effective advocates than we ever dreamed we could be.
Nancy, thank you for those beautiful words. Bill has an extraordinary ability of making friends wherever he goes. And this includes conference panels discussing the intricacies of antitrust law. And if you can make friends at a panel discussing the intricacies of antitrust law, you can make friends anywhere because those are typically pretty boring. It was on one such panel, though, that I understand Bill, you met our next guest and struck up an incredible friendship that not just spans many decades, but spans the ocean itself. During his time as AAG, Bill prioritized international cooperation among antitrust enforcers. This cooperation has truly strengthened the global community by deepening our international connections and allowing us to find common ground, something that is just so important to the work we do. Though she cannot be here in person today, I am delighted that my friend, Margrethe Vestager, the recently departed Executive Vice President of the European Commission, wanted to share her remarks on a video screen here to honor the wonderful Bill Baer.
I have known Bill since 2015. We first met at the ABA meeting back in spring 2015. Even then, he was already one of the most respected voices in competition law. So I made a point of carefully listening during our many discussions together. Those discussions, they took place over the course of many years. In fact, all throughout my time as EU Competition Commissioner. In nearly a decade, I can hardly think of a topic that we didn't discuss. Merger review, principles of remedies and liability, market power, market definition, and what it means to deliver effective competition for consumers and for citizens. I have learned an awful lot from Bill about all these things. He has that wonderful gift for explaining complicated things in a straightforward way. The mark of someone who really, really knows his stuff. But I've also found one of Bill's great strengths lies in his ability to listen. Some people reach a certain point in their career and begin to close their minds to new ideas, but not Bill Baer. On the contrary, with his innate curiosity and passion for competition law, Bill has remained attentive to the changes digital markets bring to our work, seeing trends before many others could. And that is why his voice has been crucial. As a practitioner, as an enforcer in both the DOJ and the FTC, and beyond, as a fellow at the Brookings Institution. Most of all, I have found in Bill Baer a good friend. Someone to brighten up the stage at the many conferences we have attended together over these years. Our friendship spans not only the past decade, but also the Atlantic Ocean. It's one small example of how international cooperation in competition policy has a very human face. Congratulations, my friend. I hope to see you soon.
That was lovely. Just 9 years ago, our honoree today was standing right here in the Great Hall, probably at this very podium, giving remarks about a fellow visionary leader in the antitrust community. In 2015, Bill had the honor of presenting the distinguished Sherman Award to our next speaker, Judge Diane Wood, for her extraordinary influence on our understanding of antitrust law and competition policy. The Honorable Judge Wood is the director of the American Law Institute and senior lecturer in law at the University of Chicago Law School. She was also one of the nation's most respected federal judges during her time on the Seventh Circuit of the U.S. Court of Appeals, where she served as chief judge from 2013 to 2020. To borrow from Bill's remarks in honor of Judge Wood, she is, and I quote, a thoughtful and persuasive jurist, a forceful advocate, and a pioneer. Her impact on the antitrust community cannot be overstated, and we are honored to have her here with us today to deliver remarks at a Sherman Award ceremony in this same great hall today, this time to honor Bill Baer. Please welcome Judge Wood.
Well, thank you, Jonathan. Thank all of you. It is such a pleasure to be back home here in the Department of Justice with Antitrust Division people and so many others who recognize the contributions that Bill has made, frankly, to the rule of law itself. It's especially wonderful for me to have a chance, since Bill, as Jonathan said, did make some remarks 9 years ago when I was fortunate enough to receive this award. At the time, Bill commented that I would have the chance to give a rebuttal to what he had said. So here we are. The opportunity has come. But in fact, it's not much of a rebuttal because the truth is I can imagine no one more worthy of this award, no one who has dedicated his professional life more completely to the cause of effective and fair competition both within the United States and globally. No one who knows all of our agencies so well, the Federal Trade Commission, the Antitrust Division, and no one who has been an independent thinker, staying above and beyond and over the intellectual fashions of the day, looking carefully at what this law is, where did it come from, and how should we enforce it. I first worked with Bill, I think this is right anyway, when he was serving as director of the Bureau of Competition at the Federal Trade Commission, which had just snagged Bob Pitofsky to be its chair in the early years of the Clinton administration. I had known Bob from Georgetown Law Center, where I briefly had taught, and I quickly came to see what an astute choice he had made for his #1 competition law official. Even though I left the division in mid-1995 to join the Seventh Circuit, I always felt that part of me remained here, which is a feeling shared by many alums. I wasn't sure how much of an opportunity I would have on the court to write antitrust opinions, since we were a little antitrust heavy in those days. I stood third in line behind then Chief Judge Richard Posner and Circuit Judge Frank Easterbrook, who I need not remind you were associated with certain schools of thought. And I wasn't, as it happens. But I caught the brass ring when the administrative appeal from the Federal Trade Commission's full-blown merits opinion in the Toys R Us case reached the Seventh Circuit and was assigned to my panel, which, in addition to myself, included Judges Coffey and Caney, not Judge Posner or Judge Easterbrook. Chairman Potofsky had written a lengthy opinion for the commission, finding that the network of agreements that Toys R Us had forced on all the major toy manufacturers violated the competition provisions of the FTC Act as both unlawful horizontal and vertical restraints, and the commission was defending both its liability finding and its choice of remedy before our court. I was not expecting to see Bob Potofsky at the podium. That would have been quite a break from tradition. But when I quickly looked over the morning sign-in sheet for the lawyers, I saw that the FTC would be speaking through Bill Baer. That was both a signal of the importance the commission attached to the case and also of its confidence in Bill. And Bill, don't make any mistake about it, had a serious job to perform. There was nothing obvious about the outcome. The horizontal theory had to overcome the fact that the evidence of agreement was entirely circumstantial, and nobody was quite sure how much you had to show or not show to make that work. The vertical theory had to overcome a long line of Supreme Court decisions that were, shall we say, casting cold water on the idea that consumer welfare harm could be shown from vertical agreements. But in the end, thanks in no small part to Bill's advocacy, we ruled for the commission, and I was lucky enough to write the opinion. We found it unnecessary to reach the vertical theory because we thought that the result rested comfortably on an interstate circuit type of horizontal agreement. In the years that followed, Bill's and my paths crossed from time to time. But the one I will single out is emblematic of what you've just heard from Commissioner Vestager, competition policy at the global level. This, of course, is your classic win-win. It helps the United States by assuring that the goods and services that U.S. entities sell and buy in international commerce are not burdened with anti-competitive overcharges or restrictive practices. Competition laws, as most of the rest of the world calls them, were starting to proliferate at the time I served as Ann Bingaman's international deputy, but we were talking at that time about 40 or so laws in existence. By the time Bill was around, there were some 130 different competition laws, and the need for some form of coordination was apparent. Thanks to organizations such as the International Competition Network, the tireless work of the Competition Committee of the Organization for Economic Cooperation and Development, and a huge network of bilaterals, which exactly you saw, help make it real, help make particular cases get prosecuted in the most effective way possible. That coordination among the countries around the world has flourished. Toward the end of Bill's time as Assistant Attorney General, a delegation, including General Counsel Kelly Welsh from the Department of Commerce, Bill, several other judges, and myself went to the People's Republic of China to discuss intellectual property and competition law issues. Now, we all understand, Bill would be the last to be under the illusion that what the Chinese are doing with their Anti-Monopoly Act is a carbon copy of our Sherman Act with its accumulated wisdom. But nonetheless, visits like this are investments in the future, and Bill was as fine a representative of the United States as one could wish. That visit was also an important reminder that cooperation is possible in a discrete area, such as competition law, even if both sides have their differences. The importance of these relationships continues to this day, as I'm sure you've all seen that the Chinese are taking a look at NVIDIA, and that probably won't be the last thing, but it's much better to have the door open, and Bill recognized that. Again, effective competition enforcement at the international level is a win-win for all participating countries. After a brief stint as acting Associate Attorney General, Bill returned to the private sector. But of course, this is Bill, so this did not spell the end of his engagement with antitrust. It just opened a new chapter for him. So I'll just conclude by reminding you of some remarks that he made 3 years ago at the 21st Annual Loyola Antitrust Colloquium, ably put on every year by Professor Spencer Weber Waller. "This is no ordinary time," Bill warned. "The most interesting debates over the scope, goals, and capabilities of antitrust law that we have seen in decades are underway. And that is so for several reasons. It's been 50 years since the Supreme Court's General Dynamics decision signaled the end of presumptions based solely on market power and a more economic approach to antitrust law, and nearly that long since the Supreme Court's pivotal decision in Continental TV against GTE Sylvania, welcoming the Chicago School into the halls of the Supreme Court. Scholars now have the data to assess whether the assumptions of the Chicago School have been borne out in practice, and to consider whether other approaches would have been or would now be better. The rise of big tech is another wake-up call. The pace of change is another challenge to antitrust, although many times antitrust has been written off the table as, oh, you know, we just can't move as agilely as we need to because markets are changing. And we've usually been wrong about that. Antitrust is a very robust area, and it does adapt to these kinds of changes. Bill singled out at the colloquium 5 issues that demand our attention. I won't go through them all now, but it shows the clarity of his thinking about antitrust. How should we approach the increase in concentration? How should we think about dominant firms? What are we doing with standard essential intellectual property rights? And so many other things. No one should doubt the magnitude of these challenges, but never one to shy away from the ambitious approach. Bill identified 3 potential ways they could be attacked. The first was just maintaining the status quo. The second was continuing to seek incremental change by persuading the courts to expand the boundaries of whatever it is we have right now, a consumer welfare model perhaps. Or third, more ambitiously, obtaining legislation from Congress that will bring antitrust into the 21st century. Bill opted for the third path. I'm sure the senator will be glad to hear. There's nothing wrong, as I have myself testified before Congress, with going back to Congress and seeing what can be done. No one, certainly not Bill, thinks that legislative change is ever easy, but he just may be right that this is the time. Politics has seen stranger bedfellows than the ones we would need for such change. So when it starts to happen, you can be sure that Bill Baer will be at the forefront. He is indeed a worthy recipient of the Sherman Award, and I am greatly honored to have the opportunity to contribute today.
Thank you, Judge Wood. What an honor and a privilege to hear from you, and those remarks are so important, timely, and absolutely essential to celebrate the legacy of the great Bill Baer. I'd like to share a few thoughts from myself right now. Every generation, somebody comes along who's just a cut above, somebody who's a leader that demands respect, admiration, reverence. Someone who's just a little smarter, a little bit more savvy, sometimes a little funnier, just a little bit more charming. For the antitrust community of my generation, that person is Bill Baer. I'd like to take you back on a little bit of a journey, personal journey. It starts in summer of 1996. I pack up my car from St. Louis to drive to Washington, D.C. after my first summer of law school to begin an internship at the Federal Trade Commission's Bureau of Competition. There, I encountered two giants. People that I said, when I grow up, I want to be like them. People who are larger than life, they were smarter, they were more dynamic, and they led by example, with intellect, with vigor, with commitment and passion. I encountered the great Chairman Bob Potofsky of the FTC and the Director of the Bureau of Competition, Bill Baer. I had the privilege of working that summer at the Federal Trade Commission and loved it so much under Bill's tenure that I decided to come back for my second summer in 1997 and then return full-time in the fall of 1998. I literally owe my career to Bill Baer. I was a junior lawyer at the FTC, just getting started, but it was a time of excitement. In a sea of what seemed like receding antitrust enforcement, Bill motivated his staff to take chances. He motivated his staff to bring hard cases. He motivated his staff to litigate. And that's what we did. In doing so, under Bill's tenure and leadership, he built the foundation for the modern framework for antitrust enforcement. It is true that we stand on the shoulders of giants, and Bill, your time at the FTC are the shoulders that we stand on today. Staples, Toys R Us, drug wholesalers, so many cases demonstrated that if you try, if you bring good, serious, smart, capable cases, be careful, little girl. She's so sweet. Hi. If you bring great cases to courts, they will respond. And the FTC showed that if you have courage, you can win. And Bill always encouraged the commission to bring cases, to investigate with courage. Let's fast forward to January 2013. Bill Baer takes what I view as the best job in the entire federal government, Assistant Attorney General for the Antitrust Division. After a time when the Antitrust Division had seen some difficult periods, difficult cases, Bill instilled a sense, again, of courage, again, a sense of togetherness, a sense that if we try, we can do. And so it wasn't easy. Bill confronted some of the most difficult challenges anyone in my job has ever confronted. At a time when people were concerned, as they still are today, about consolidation in the healthcare industry, just like with drug wholesalers generation before, Bill confronted not one, but two simultaneous mergers, the largest health insurance companies in the country. The standard would have been to say, oh my goodness, do we have the resources? Do we have the wherewithal to litigate both mergers at once? Can we afford to do it? Do we have the litigation expertise? Maybe we should settle. Bill said, not on my watch. He said, we are going to litigate both cases. And what did he do? He litigated both cases. And guess what? He won both cases, working with the incredible team at the Antitrust Division. And those cases, again, created the framework for modern antitrust enforcement and demonstrated to an antitrust division that if you have the willingness to fight for what you believe is right, you can litigate a case, you can bring it to a court, you can explain it to a judge, and the law will meet you there. That's exactly what Bill did. He also presided right at his, out of the gate over the first big tech trial, the eBooks case against Apple, again, taking on one of the biggest companies the world has ever known and will ever see, and Bill, working with the incredible team at the Antitrust Division, succeeded. He also presided over probably the most successful tenure of criminal antitrust enforcement in the history of antitrust, going back to 1890, the inception of the Sherman Act. That is an extraordinary achievement. Also, and I say this as somebody who has spent some time in St. Louis, that at a time when we never thought we could see real competition for the king of beers, We now have the top beer in the country that was made possible because of Bill Baer. What's that?
I hope it's chilled.
I won't do it. Not till later when we have a party. Bill led the division with grace, with care. He led with confidence, sparkling intellect, empathy, humor, seriousness, and most of all, integrity. And that is something incredibly special that we only get once in a generation. Taking you along my journey, I'd like to fast forward to the summer of 2021. I had the privilege and honor, the greatest honor of my professional life, which is to be nominated by the President to serve as Assistant Attorney General of the Antitrust Division. One of the first calls I got was from Bill. He was so warm and so gracious. He said, "Come meet me in my office," which I learned was outside a coffee shop outside in Sangamore, Bethesda. And it was there I went to AAG school. And over many coffees and many conversations, Bill taught me about managing up and managing down and managing over, lessons that I would take with me throughout my tenure at the Antitrust Division. He shared his wisdom, his humor, tools of the trade, which I won't disclose, proprietary. And during my time at the division, Bill was always there. He was always on my side when I had a tough question or a tough call. I knew I could always call Bill, even without disclosing confidential information, and get a steer. When I had questions about management, questions about how to handle the division, especially early on, I can give Bill a call, and that sense of wisdom and calm and grace helped me through. During those first months, which were tough, even when we saw a few losses, knowing that we had to stick with it so that we can build what we knew would be a formidable antitrust division that has since gone on to have a tremendous historic string of victories. Bill was there, told me to stick with it, keep our eye on the ball. And he was there publicly, whether it was a hit on CNN or a quote to the Wall Street Journal. Bill was always there in a true, selfless way to be on our side. Bill Baer is antitrust, but antitrust is not Bill Baer. He is so much more. Bill is at his brightest, his happiest, his most compelling when he talks about his beautiful family. He talks and glows when he's near his wife. His kids mean everything to him, but it is perhaps most evident when you can witness the glow, the pure joy that glows from Bill when he talks about his grandchildren who are here today. It is unqualified and it is unending, and it is a beautiful, beautiful thing to see. Bill Baer is one of the finest antitrust lawyers and leaders ever to walk the planet. He is on par, and he is our modern-day Thurman Arnold and our modern-day Robert Jackson. But his glow as a husband, father, and grandfather is without a doubt his finest achievement. Just as I had the privilege early in my career of thriving in the glow of people like Bill Baer and Bob Pitofsky, Bill had the same opportunity early on in his career. And it's fitting that today I have the privilege of inviting in a special guest who Bill knew early on in his career, who has gone on to do a few things, a little judge this, a little attorney general that. But I think perhaps his claim to fame now is having worked with Bill in practice. Someone who is an extraordinary antitrust lawyer in his own right, an incredible leader, and someone who has really been a vision and a guardian angel for the Antitrust Division. It is my distinct pleasure to welcome the Attorney General of the United States of America, Merrick Garland.
Okay. Thanks, Jonathan. Thanks to all of you for coming here to celebrate Bill Baer, a legend of the antitrust bar and my friend. Bill and I met more than 40 years ago when we both joined Arnold & Porter after our first tours of duty in the government. Bill's was at the FTC, and mine was at DOJ. At Arnold & Porter, we had the great good fortune to work with the legendary antitrust academician, enforcer, and lawyer, Bob Pitofsky, who was himself a Sherman Award winner. As it turned out, none of the three of us could stay away from public service for very long. As you know, Bill would go on to become the only person to head antitrust enforcement at both the FTC and at DOJ. He won important victories in complex and high-profile cases, and he helped to usher in a new era of antitrust enforcement. Global Competition Review has twice named Bill the best competition lawyer in the world. Best Lawyers has twice honored him as the best antitrust lawyer in Washington. And the FTC has given him its version of the Sherman Award, the Miles Kirkpatrick Lifetime Achievement Award. So it was about time that Bill got the only antitrust award that really matters, the Justice Department's Sherman Award. It is deeply meaningful to me to be here to see this. In my previous stint at Maine Justice, I had the honor to be on hand when the Antitrust Division gave out the second ever Sherman Award to my friend and former professor, Phil Arita. Today, in my final tour of duty, I get to see the award given to Bill, my friend and former colleague. And just a quick note to the ethics police out there, I had nothing to do with choosing the award winner in either case. Now let me just say a few words about Bill's extraordinary tenure at the Antitrust Division and in competition. I know many of you have already raised a pint to Bill's honor this afternoon, and as you've heard from Jonathan, that's a fitting tribute to the man who led the department's suit to block a $20 billion deal that would have brought Modelo entirely under the company that owns Budweiser. Bill left Wisconsin for law school in 1972. Now he can go back to Milwaukee and say he saved beer. Way to go, Bill. In addition to challenging the InBev-Modelo merger, Bill led the department in preventing a merger of Chicken of the Sea and Bumblebee in an already overly consolidated market for canned seafood. In doing so, he probably saved the company from some embarrassing jokes about the birds and the bees. Bill also intervened in the proposed merger between U.S. Airways and American Airlines, securing a settlement that required the airlines to relinquish their stranglehold on more than 130 slots at the busiest airports in the country, including DCA. Bill used to smile when he looked out his window on the third floor of this building and saw Southwest airline flights departing from DCA, something only possible because of that settlement. Through his work, Bill has shown a generation of Justice Department attorneys and so many others why taking up these cases is so important. Today, Bill is rightly regarded as a preeminent expert on antitrust issues of every kind. Indeed, as I was preparing for the transition to Attorney General in early 2021, I turned to several articles and reports that Bill wrote in order to brush up on the most recent developments in antitrust law. So thanks, Bill, for brushing me up on the network effects of two-sided platforms. In those reports and articles, Bill advocated for the actions he believed the next generation of antitrust enforcers should take. He argued that antitrust agencies should be advocates for a more robust approach to enforcement, insulated from political interference. He made the case that preventing consolidation, particularly in online and tech markets, is an urgent mission. He urged the antitrust agencies to be more assertive in challenging acquisitions of nascent competitors, potential entrants, and those in vertical relationships where the combination reduces competition. He challenged them to take a fresh look at the behavior of dominant firms that has the purpose and effect of limiting the ability of actual or would-be competitors to offer meaningful alternatives to those with monopoly or near monopoly power. And he insisted that analytically sound and fact-based antitrust enforcement would provide the public, the business community, the courts, and the legislative branch with assurance that it is the merits that count, not political ideology, whim, or the desire to pick winners and losers in the economy. Gee, Bill, sounds just like what the Antitrust Division has been doing for the last few years. Thank you for the advice. Bill also warned that more personnel would be needed if antitrust enforcement were to fulfill its role as economic cop on the beat. Bill did not know the half of it. When I was sworn in as Attorney General in early 2021, there were just over 650 employees in the Antitrust Division, far fewer employees than when I first joined the Justice Department in 1979. Needless to say, that dramatic reduction in force occurred despite the tremendous expansion of our economy and of merger activity during the prior 4 decades. I'm pleased to report that today the division has over 800 employees and still growing. And speaking of personnel, during the transition, I also sought Bill's advice in identifying the right people to fill important roles in the division and the department. So if you're in this room today, you may well owe a thank you to Bill as well. In addition to Bill's legacy as an advocate and influential voice in antitrust law, another legacy of his time as leader of the division was, as Jonathan said, his kindness. Bill was beloved by the lawyers and staff of the Antitrust Division because he got to know them personally and invested in those with whom he worked, from section chiefs to junior line attorneys, to staff attorneys, to paralegals, economists too. He championed the division's people, and in so doing, he furthered its mission. Bill spent his final months at the Justice Department serving as acting Associate Attorney General. It was a fitting promotion for an extraordinary public servant. It meant that the rest of the department got to experience a little of what the Antitrust Division had, a kind, wise, and inspiring leader devoted to the people of this department and to people of this country. Bill's legacy is all around us. It is in this room, full of a generation of antitrust leaders he mentored and inspired and worked with. It is on our grocery shelves. It is soaring through our skies and landing in our airports. Throughout his life, Bill has been a fierce believer in competition and in protecting competition in almost everything he does. I say almost because his friends revealed how in law school, Bill successfully eliminated the competition, beating out the extensive roster of other students striving for the attention of his now wife, Nancy. And I am told he did so in a bowling shirt, as befits any proper son of the Midwest. Bill's proudest legacy, as Jonathan said, is his family. His wife, Nancy, sons, Michael and Andrew. It should come as no surprise that Michael managed to forge his own path to the Justice Department, where he has served in multiple important roles in the Civil Division. And as Jonathan said, I'd like to recognize the lights of his life, his 2 granddaughters, Eliza and Grace. As a fellow grandfather, I know he takes more pride in them than in any award we could bestow. So, Bill, this honor is so well reserved. I join your many friends and family in raising a point to you at the Antitrust Bar. Congratulations, my friend.
Bill, this Modelo's for you. So now we are going to have the great pleasure, along with the Attorney General of the United States, to bring Bill, and we'll take a to the podium. In recognition of a lifetime of achievement in the field of antitrust, it is my privilege and the privilege of the United States Department of Justice to present the John S. Sherman Award on behalf of the Antitrust Division and the DOJ to the Honorable William J. Baer. Congratulations.
Wow. Over the top doesn't come to describe what we've just heard today, and another term is highly exaggerated. But I'm grateful for all of those who came here today. Doha mentioned the family. As the Attorney General just said, I was fortunate to marry Nancy Hendry, the law school classmate whom I most admired, and I still do. We came to DC together in '75 because we both embraced the value of public service. And we each benefited over the course of our careers from a number of opportunities to do just that. Andrew's a counselor, Andrew Baer, our younger son, at Winston Churchill High School in Montgomery County. Last June, he married the fabulous Maggie O'Connell from Kensington, Maryland. And his brother Michael, as the Attorney General said, is a lawyer and no great stranger to the Department of Justice, to the Great Hall, and even to the third floor, although he did turn the wrong way getting off the elevator and ended up in the civil division. Michael married a very talented English woman, Mary Nugent, and together they've gifted, as you've heard now, us with 2 shared custody grandchildren. 5-week-old Grace Catherine Baer is here, as is the blueberry muffin monster, Eliza Judy Baer. Indeed, we had blueberry muffins this morning before we walked to daycare together. I'm also grateful that 2 of my 4 siblings are here. Tom Baer from Mountain View, California, Kathy Monroe from back home in the Milwaukee area. And then there's Sally Petofsky, an honorary member of our family, just as Bob and Sally made us a part of theirs. Thank you, Sally. Before I thank the folks on the dais for their overly generous remarks and well-deserved poking fun at my expense, I need to honor Shawnee Ball, seated back here, whose voice has graced this hall on so many occasions. We last celebrated here in 2016, and as I left this building in early 2017 under protest, I wondered if that might have been the last time I'd be privileged to hear you sing the national anthem. Indeed, at the time I was worried it might be the last time I was invited back to the Justice Department. But thank you for coming out of retirement and singing at this event. Shawnee, you lift us up with your presence and your voice. Now, I'm glad the Attorney General was able to come by. We've been friends, as he said, for quite a long time. And he is, for obvious reasons, my public service hero. As you know, he has long been interested in effective antitrust enforcement. And he's been, I know, incredibly supported, along with the rest of the DOJ leadership, of Attorney General Cantor and his talented team. But obviously, the most important thing to talk about when you mention Merrick Garland has been his work as a tireless and effective leader of this department over these last 4 years, under the most challenging of circumstances. And when, in the near future, we're able to use the search engine of our choice and not just the default, and we enter the phrase impartial justice, I'm confident it will immediately link us to Merrick Garland's Wikipedia page. Now let me say a word or two about the people who exaggerated on my behalf on the dais. Nancy Rose. Nancy, we at the Antitrust Division were so excited when you agreed to join us as Deputy Assistant Attorney General and Chief Economist. My predecessors at the Antitrust Division and down the street at the Federal Trade Commission had recruited you for years because of your contributions to the industrial organization and competition fields. But somehow we got you to say yes. And you did not disappoint. Your brilliance showed through immediately. But what also impressed us was how quickly you got with the program. You became the consummate leader and team player. Much of the success of that last 2.5 years during the Obama administration is owed to your brilliance, but also to your emotional intelligence. You, Nancy Rose, made us better. Also, I mentioned that you exaggerated a bit. I do need to point out one understatement. You mentioned that I had bought pizza after the government shut down in 2013 for a litigation team. I bought pizza for the entire Antitrust Division. And it was much appreciated. And then I went home, and a couple days later, Nancy returned from an overseas trip. And she said, "You spent $1,800 on pizza while I was away?" And I said, "Well, you know, Eric Holder and Tony West said we should really go out of our way to welcome people back." And then came the cross-examination. Did either of them mention pizza? Did either of them suggest $1,800 of Domino's pizza? It was the most brief and brutal cross-examination of my life, because the answer is obviously no. Margarita Vestager, you heard her lovely tribute, and as you could tell, we became good friends. She's a competition enforcer extraordinaire. For 10 years, she steered the DG competition ship, and she did it all, from taking on big tech before it was fashionable, to resisting the influence of some in Europe who wanted to suspend merger enforcement in the hope of creating national champions, a strategy that has been oft-tried and almost always just results in diminished competition, lower output, and higher prices. And Margarita did it with grace, as you saw, self-effacing good humor, and a wonderful ability to explain to the average citizen of Europe why and how competition policy and competition enforcement matter. Judge Wood, welcome back. Diane, we were privileged at the Antitrust Division at Jonathan Stanton to honor you with this award 9 years ago, and you really, really earned it. We honored at that time your teaching, your scholarship, your work with Bob on his beloved casebook, your prior service here at DOJ, and your ongoing service on the Seventh Circuit. I am grateful, too, as you mentioned, that you were on the appeals panel for my first and last appellate oral argument, where I defended the FTC's Toys R Us decision. And as you note, you wrote the unanimous opinion upholding that decision. the antitrust community, antitrust enforcement community, is very grateful. In more recent years, many of us in the antitrust field appreciate how you politely but firmly challenge those champions of antitrust under-enforcement, who, to quote a Bob Pitofsky turn of phrase, overshot the mark, leaving way too much consumer and competitive injury unaddressed. But you yourself put it even better a few years ago in Senate testimony, I think before you, Senator Klobuchar, when you observed, true as it might be that the antitrust laws are for the protection of competition, not competitors, you then went on to say it is equally true that without competitors, there will be no competition. I use that quote a lot, and on at least one or two occasions, I attributed it to her. So, Jonathan Cantor, what can I say? I thank you for your kind words for this award and listening to my views on various issues over the last 3.5 years. Contrary to the way you described it, I'm pretty sure that you only asked for those views on one or two occasions, but you got them frequently. I also need to confess that as you have been more and more successful in this job, my description of my role at the FTC in your hiring, your promotion, and your success as a trial attorney has grown as well. Now, I know this has been about me, but I'd rather spend my last few minutes talking about the accomplishments of the division under your leadership and those of the commission under Lena Khan and her colleagues. I remember well the early days of the Biden administration and the worries voiced by some that the neo-Brandesians were the barbarians at the antitrust gate, about to pursue a reckless and doomed to fail effort to radically change antitrust jurisprudence, to somehow force the courts to abandon years of common law development of the Sherman, Clayton, and FTC Acts. That's not what happened. It's not even close. A more fair characterization is that you and your colleagues repeatedly asked the question that is fundamental to effective antitrust enforcement. Where is there significant harm to competition, harm to consumers, harm to workers that we are missing or inadequately addressing? You investigated those harms, you challenged bad actors in court, and you relied on longstanding antitrust jurisprudence to justify those challenges. And to the surprise of some, not me, you have prevailed. That is a lasting antitrust legacy of which you can be proud and for which the American people owe you our thanks. I need to wrap this up. I think they're going to reopen the bar. Two last points. First, this award honors an individual. I appreciate that. But I know firsthand that what you do here in the antitrust division, Doha and Jonathan, and what goes on down the street at the FTC is and always has been a team sport. It requires hard work and collaboration between dedicated career public servants and those fortunate enough, like me, to parachute in on occasion and join the team. Whatever success we celebrate today resulted from those tireless collective efforts. And finally, I want to thank those of you who came today to acknowledge and thank the friends and colleagues from every part of my professional and personal life who honor me with their presence here today. Family, friends from college and law school, the Justice Department, the Federal Trade Commission, Arnold & Porter, and my current happy home at the Brookings Institution. I am blessed, and I thank you.